a Jewish boy growing up in a safe place in a small town in western Pennsylvania, far from a ravaged Europe. And there we celebrated the verdicts as justice done, which they were. Today I want to celebrate them as justice begun, the beginning of humanity's long struggle to learn how to deal with the evil we do to each other. I want to begin with the anomalies of the Nuremberg trials, and then suggest a somewhat unconventional view of their meaning. And here's a list of the four most important anomalies. 1. The International Tribunal consisted of only 4 nations. 2. These nations had just won a war and were bringing the losers to what looked like victors' justice. 3. The leaders of one of these nations, the Soviet Union, were guilty of all the crimes charged against the German defendants, and the leaders of the United States and the United Kingdom were guilty of some of them. 4. The charter under which the trials were conducted listed crimes, the crime of aggression, crimes against humanity, that many lawyers thought were not previously known to international law. Hence, the trials were said to be an example of post facto justice. I acknowledge the criticism these anomalies have generated, not only from German defense lawyers at the trial itself, but also from other lawyers from other countries, even from the Chief Justice of the United States Supreme Court, Harlan Stone, whose colleague Robert Jackson led the Nuremberg prosecution. Nonetheless, taken together, the anomalies made for an extraordinary moment in political and legal history, a moment of something like world government. Though this moment has had significant effects, we have not seen anything quite like it in the decade since 1945. Trials like those held in The Hague for crimes committed during the wars of the former Yugoslavia and in Arusha, Tanzania, for the crimes of the Rwandan genocide owe much to the precedent of Nuremberg, but fall far short of a full reenactment of what happened 70 years ago. Consider first the London Conference, in which the United States, Britain, France, and the Soviet Union hammered out the charter that served as the constitutional basis of the Nuremberg trials. The charter was produced, I want to suggest, through an act of legislation that involved argument, bargaining, and compromise, very much like what goes on in a political assembly. The charter can be read, as the prosecution insisted, as a codification of existing law, treaty law, common law, legal practice. But it can also be read as new law, a revolutionary enactment initiating a new legal order. Both these views are defensible, since the new legal order, if that's what it was, grew within the old order and reflected the transformations in moral consciousness and in moral and legal practice that always precede formal legal change. So it is possible to argue that the defendants knew, certainly they knew, the wrongness of what they were doing, even if they didn't believe in its literal illegality. But the only point I want to make now is that the judicial moment in Nuremberg was preceded by a legislative moment. The inclusion of the Soviet Union in these two moments was, no doubt, morally strange, but it was crucial to the internationalism of the trials. No state had suffered more than the Soviet Union in the war, or contributed more to winning it. And for those reasons alone, it had to be, and rightly was, included. But its presence also meant that the trials were not an Atlantic or Western production. They were, so to speak, international in the context of the European war. Of course, the Red Army was sitting in half of Europe, so the Soviets could hardly be denied their role, and the armies of the United States, Britain, and France were sitting in the other half, ensuring their role. These were indeed victorious armies, but that is precisely what made them the effective executive arm of the London Conference and the Nuremberg Tribunal. They rounded up the defendants and brought them to the courtroom, and they guaranteed that there would be no efforts in occupied Germany to resist the verdicts. When the major world powers don't collectively win a war, or support the winners, or at least accept the outcome, there can't be an international tribunal bringing war criminals to justice, which is why no such tribunals were convened after the Korean or Vietnam wars. That doesn't mean that all post-war justice is victor's justice, but it is, to some degree, great power justice. The unity of the powers in 1945 made possible a radical conjuncture. Each of the conventional three branches of government were strongly represented internationally. In addition to the judicial proceedings, there was actual legislation and there was active executive enforcement. This conjuncture has been very difficult to reproduce in the years since. Consider a useful and sharp contrast to the Nuremberg moment. The 2009 case of the International Criminal Court and the President of the Sudan tells us a great deal about the difficulties of global justice today. The court's indictment of President Bashir for crimes against humanity in Darfur may one day be recognized as a landmark in the defense of human rights. Decades from now, it may serve as a critical precedent, following upon and strengthening the Nuremberg precedent. In 2009, however, the ICC was acting like the judicial arm of a world government when there was no world government. This is an example of what I've called in another place the politics of pretending. The ICC had no way of bringing Bashir to trial, nor could it control events in Darfur. Its decision put people at risk, and the court was unable to protect them. When Bashir expelled all aid organizations from the Sudan, he was retaliating against the Darfurians for the ICC's action against him. He was deliberately provoking a humanitarian crisis, or more accurately, intensifying the crisis that already existed. And there was nothing that the court could do or that any international agency could do in the name of the court. The ICC most simply had no executive arm, but it acted as if it did, pretending that there is an effective system of global justice, that there is some kind of world government, when no such thing exists or will exist in the foreseeable future, seems to me an example of moral and political irresponsibility. I don't mean to sound like an advocate of world government. A global state would probably be the soulless despotism that Immanuel Kant warned us against. It would probably take shape as sovereign states did in the early modern period as an absolutist regime. There is no good reason right now to abandon the pluralism of international society. But I am in favor of moments of world government, when powerful states and other states too, together with organizations like the UN and the ICC, succeed in constructing the legislative basis, the executive power, and the judicial authority necessary for a strong international response to wars and massacres. That is what Nuremberg represented, and we must work for its repetition. The Nuremberg trials, writes Telford Taylor, were not conceived as a continuing enterprise, but as an episode that would leave an enduring judicial monument. Given the recurring violence of the world we live in, we need recurring episodes of the same story. It is important, though, that the men and women committed to this recurrence aim as best they can at the full three-branch conjuncture that made Nuremberg's success possible. The International Criminal Tribunal for the former Yugoslavia, the ICTY, is an example of near success in this project. It went to work in the aftermath of terrible wars, civil wars, with authorization from the UN Security Council, proof of the momentary unity of the major world powers. Resolution 827 was the charter, the legislative basis of the ICTY. But the tribunal had no enforcement mechanism of its own. Its greatest problem in its early years, and I'm quoting now from the ICTY's website, its greatest problem was its inability to arrest suspects. Both the courts and the Serbs, I'm quoting still, obstructed the tribunal's work, with the authorities in Belgrade demonstrating the most consistent, open hostility. The tribunal was helped by the formation in 1997 of a multinational stabilization force with the power to arrest and detain suspects. But it still took many years before most of the indicted persons were brought to court. Fortunately, the obstruction of the tribunal's work did not lead to violence, only to long years of judicial work and to a sense among some of the war's victims that justice delayed is justice denied. Overall, however, the ICTY has been exemplary. Many Serbs complain that from the beginning this was victor's justice aimed narrowly at them, but members of Yugoslavia's other nations were prominent among the defendants, and the judges weren't the victors. They were recruited from many nations, and mostly not from the most powerful nations. Malta, Egypt, Canada, Belgium, South Africa, Sri Lanka, Italy, and others too sent judges to the ICTY. The Rwanda story is somewhat less of a success. Here again, the tribunal operated under a UN Security Council charter, Resolution 955, adopted in November of '94, but without its own enforcement mechanism. The Rwandan government that replaced the genocidal regime acted as the executive arm of the tribunal, and it delivered indicted individuals to Arusha for trial. But its role meant members of the RPF, the guerrilla movement from which the government descends, were immune from prosecution, though some of them are certainly guilty of war crimes and even of crimes against humanity. Had there been an internationally sponsored intervention to stop the genocide, the tribunal would have had an army at its command, and its reach would certainly have been wider. Nuremberg followed upon a world war, and it was the decisive victory of the Allies that made the brief moment of world government possible. We should be thankful that there are no more world wars. But we can't be thankful for the multitude of bloody engagements of different sorts that we live with today, sometimes across international borders, more often inside the borders of troubled, divided, and failed states. International courts are active in some places, but not in others, here but not there, for reasons that aren't easy to make out. We are glad when they can bring criminals to trial, as in The Hague, but this isn't yet the full Nuremberg legacy that many of the 1945 prosecutors hoped for, and that many of us still hope for. Perhaps we haven't fully grasped how crucial it is that judges in international society have armies that can act for them, just as judges in domestic society need the police to act for them. So we have a precedent that those of us in this courtroom today wish were more fully realized. We would like to deal effectively and fairly with the aftermaths of wars and civil wars. We make do with efforts that inevitably fall short, with justice delayed and justice incomplete. World government as a practice for the moment, a recurring episode, is not right now reliably established. But the idea is alive, and we have examples of how it can be partially realized. That's the real legacy of Nuremberg, not a judicial system, but a set of judicial principles that wait, so to speak, for the occasions when we should and when we can enforce them. These principles are very important, but they are also radically under-specified, largely because there have been so few moments in which the world acted in their name. I'm going to consider 6 principles. The list is my own, nothing official. It overlaps with the principles of the London Charter, which were affirmed by the UN General Assembly in its resolution of December 1946. The first principle is that acts of state can be criminal acts for which political leaders should be held responsible. Heads of state are subject to judgment, more often, in fact, to moral than to legal judgment, but the principle is a legal principle. Lesser state officials can also be held responsible for the illegal acts of the agencies they run, and so can the executive officers of companies and corporations. Aggression is the most important of the criminalized acts of state, and yet no head of state has been tried for aggression since Nuremberg. Sometimes the failure to try heads of state has to do with insufficiencies of executive power. The Korean police action, authorized by the UN's General Assembly in 1950, was certainly a world government moment, but there was no agreement among the great powers. Only an international tribunal that included China and the Soviet Union could have brought the rulers of North Korea to trial for the invasion of the South, and both China and the Soviet Union insisted that the invasion was not a crime, indeed wasn't an invasion. Sometimes the reasons for this failure are prudential, as we can see in the first Gulf War of 1991. This was again something close to a world government moment, given that the Security Council condemned Iraq's occupation of Kuwait and authorized all necessary means to end it. But it would have taken more of a war than anyone wanted to fight to bring Saddam Hussein to trial for the attack on Kuwait. In any case, it isn't at all clear these days what sorts of state action constitute aggression. Is a preemptive strike like that of Israel against Egypt in 1967 an aggressive act? Should we call the American invasion of Iraq in 2003 aggression, when it was welcomed, though only briefly, by most of the inhabitants, the Shiites and the Kurds, of the invaded country? I thought the war against Iraq was an unjust war, but I'm not sure it was a war of aggression. I think we need a more complicated legal vocabulary. The UN has failed in several attempts to define aggression. And here the moral arguments among just war theorists are probably well ahead of the arguments among lawyers, though I understand that there is an ongoing effort at the ICC to bring aggression into judicial view. What we need is a new legislative act. And until we get one, I'm afraid that aggression is pretty much lost to international law. The second principle is that acts of war can be criminal acts, even if they are claimed to be militarily necessary. And that the soldiers and officers responsible for those acts are subject to legal judgment. Both Both the Yugoslav and Rwandan tribunals have charged individuals with war crimes, violations of the Geneva Conventions, and the subsequent convictions vindicated the charges. But the greatly increased involvement of civilians in what is called asymmetric war has not yet been clearly addressed at the UN or by any of its tribunals or by the ICC. The issues are not new. Indeed, they arise in one of the most ancient forms of warfare, the siege of a city. The heavy civilian toll of siege warfare was not considered criminal at Nuremberg, hence the acquittal of Field Marshal von Lee in the subsequent trials for ordering his men to fire on civilians fleeing a besieged Leningrad. Here is the moral dilemma posed by siege warfare. The besieged army hides among the city's civilians, putting them at risk. The besieging army holds those civilians hostage by trapping them in the city. They will die of hunger and disease if the army doesn't surrender. They do die in large numbers, over 1 million in Leningrad. Which of the armies is responsible? The same question arises, though in a more immediate and intimate way, in asymmetric warfare between a high-tech army and a low-tech insurgency. The insurgents use civilians, firing from civilian cover. The soldiers kill civilians to get at the insurgents. Who is responsible? Here again, we need a new legislative effort specifically addressed to this kind of warfare and providing guidelines not only for the combatants, but for onlookers as well, whose opinions have become increasingly important, and for possible future judges. The third Nuremberg principle is that ordinary citizens of states that act criminally are not legally responsible for those actions, even if they voted for the leaders who are responsible. They are subject, as citizens always are, to the consequences of their leaders' decisions, as in the wide distribution of the cost of reparation payments through the tax system. But they do not have to stand in court, nor are they morally responsible, even though we may think that more of them should have opposed their leaders, as some of them certainly did. This principle is especially important because of its explicit denial by contemporary terrorist organizations who target civilians in democratic countries like the United States, Germany, France, and Israel, claiming that all of them are liable for the crimes of their elected governments. The deliberate killing of civilians was condemned at Nuremberg, and terrorism today is something close to an internationally recognized crime. But there are still people who claim that one man's terrorist is another man's freedom fighter, and no member of any of the known terrorist organizations has yet been tried by an international tribunal. After the 9/11 attack in the United States, some people argued for a judicial rather than a military response, but this was, I'm afraid, another example of the politics of pretending, for there was no international judicial agency capable of effective action. The idea, however, is a good one. We need a world government moment when terrorism is legally defined and successfully prosecuted. The fourth principle is that ordinary soldiers are not responsible if they fight for their country in an unjust or criminal war. The war is a crime of state for which the political and military leaders of the state are solely responsible. Individual soldiers are judged only for the crimes they individually commit. This is actually a hot issue among just war theorists today. A group of revisionist philosophers argue that if a war is criminal, then everyone who fights in it is also criminal. But I don't think that these philosophers actually favor putting the criminal soldiers in their hundreds of thousands on crime. Nor have they argued that prisoners of war should be treated in accordance with the legal or moral standing of the war they fought. Some of them accorded benevolent quarantine for the duration of the war, and others not. Given the ongoing debate, however, it might be wise to reassert the Nuremberg limitation on criminal liability. The fifth principle is that there are crimes greater by far than the crimes that states commit against each other or that individual soldiers commit against wounded enemies or enemy civilians. These are crimes against humanity, which may also be violations of the laws of war, but have now a totally different standing. In fact, I think that each of the repetitions of the Nuremberg moment, the international tribunals for Yugoslavia and Rwanda, and the hybrid tribunals for Cambodia and Sierra Leone, have been driven primarily by crimes of this kind. That crimes against humanity continue to be committed and only sometimes punished is a sign of the weakness of international justice. The world government moments have been too few. This is the clearest case where executive action needs to precede judicial action. Only a clear readiness by the major powers or by the UN to intervene militarily against mass murder will ensure that massacres are stopped, even if they are not prevented, and that the perpetrators, all of them, are brought to justice. Perhaps the readiness, if it is visible, would also make for deterrence. The sixth and last principle is that international justice has to be impartial. It has to be governed by reciprocity and equality. I'm not sure that this can properly be called the Nuremberg principle, given the anomalies with which I began, but there were intimations of the idea that Germany's military leaders should not be prosecuted for crimes that were also committed by their opponents. A clear statement to that effect was impossible in the circumstances of 1945 and 46, but when the judges refused to condemn Admiral Dönitz for his conduct of submarine warfare, the charges were not assessed. They were acknowledging the principle of equality. For the same reason, as Taylor writes, aerial bombardment had been used so extensively and ruthlessly on the Allied as well as the Axis side that neither at Nuremberg nor Tokyo was the issue made a part of the trials. And again, the same reasons prevailed in the exoneration, which I referred to earlier, of Field Marshal von Lieb for what would otherwise be crimes committed during the siege of Leningrad. These judicial decisions seem right to me, but they are not, so to speak, eligible for repetition. They should not be repeated. Here is what was needed at Nuremberg, but was not undertaken by the judges. A stern and strong statement of the criminality of, to take the most obvious example, the indiscriminate bombing of cities, and a promise that though the charges could not be assessed this time, the crime was clear and would henceforth be recognized, and anyone, anywhere, who committed the crime would be prosecuted. Who could make such a promise now? We have to be on guard against partisan and unequal condemnations, which agencies of the UN have been thrown into issue, without, we should probably be grateful for this, without being able to initiate either executive or judicial action. We should also reject the kind of random and ad hoc justice suggested by the Spanish judge who wanted to put General Pinochet on trial. He claimed universal jurisdiction, but in fact everything that justice requires was missing in this case. A clear legislative mandate, an international tribunal, and a responsive executive arm. There is only one kind of world government moment that we should look forward to and hope to see repeated and work to see repeated, when the crimes we all recognize are internationally recognized and effectively and impartially dealt with. That would be the true realization of the legacy of Nuremberg. Thank you. International law and in a standard of just war theory, we make a distinction between the justice of the war and the justice of the conduct of the war. That's jus ad bellum and jus in bellum. And the two categories are independent of each other. A just war can be fought unjustly, as, for example, in the firebombing of Dresden or of Tokyo, or the use of atomic bombs at Hiroshima and Nagasaki. And a just war and an unjust war can be fought justly. The judgments we make those two judgments independently. For the war itself, we judge the leaders of the state and of the army, the men and sometimes women who make these critical decisions. For the conduct of the war, we judge individuals for what they do at every level in the military. And we do expect soldiers who are ordered to shoot at civilians to refuse the order. And they are punishable if they participate in a massacre. But we do not expect 19 and 20-year-old men and women who are told by their preachers and their teachers and their parents and their political leaders that this war is just and that their country's security depends on fighting it. We do not expect 19 and 20-year-olds we do not require of them a judgment such that we will hold them legally responsible for the war they fight. We make a distinction, so to speak, between military orders in war itself and conscription for the war. And we may decide to honor people who refuse to fight in what they think is an unjust war, but we will not hold criminally responsible those who do not refuse. That's the conventional view. It is now being challenged by a group of philosophers who call themselves revisionists and who want to hold soldiers responsible, even very young soldiers, for the wars they fight. But they hold that principle, but they have been remarkably reluctant to apply it, to actually advocate trials for these hundreds of thousands of soldiers fighting an unjust war, like all the American soldiers in Vietnam, say. And they have not been willing to say that prisoners of war should be treated differently on the basis of some judgment that their captors make of the morality and legality of the war they are fighting. I think the revisionist principle will not survive. I think this is the work of philosophers looking for a path to innovation, when in this case, not all the time by any means, but in this case, the standard view is probably the right view. But the international equivalence of premeditated murder and armed robbery and homicide and assault have one word for all of those, for the international equivalent of all of those domestic crimes which we distinguish so carefully. And I would suggest that we need to make some kinds of distinctions of that kind in our thinking about the behavior of states. I don't think it's difficult to recognize aggressive war. I think we know it when we see it. The Italian invasion of Ethiopia, the Russian invasion of Finland, the German invasion of Poland. If you think about cases like that, I believe you can understand quite easily what aggression is and why it is a crime. It is a crime because it forces people to fight in defense of their country and their lives. Because once a border is breached, once a border is breached, a people is at threat, is threatened. And when they respond by defending their country, that offers proof that the attack was aggression. If they welcome the invaders, it is hard to call that war aggressive. It may be wrong for other reasons, but it would be difficult, in my view, to call a war where something like 80% of the inhabitants of Iraq, for a brief time, welcomed the invaders.
Ich stimme zu. Ich kann auch nur sagen, dass wir uns diesen Fragen am Ende nur nähern können, indem wir die konkreten Fälle diskutieren. Und den berühmten Fall diskutieren ist eigentlich die Annexion der Krim wirklich eine Annexion gewesen. Es gibt Leute, die dem widersprechen. Es gibt Leute, die sagen, das war eine Annexion oder völkerrechtswidrig. Aber zweifellos hatte die Sowjetunion eine Mehrheit auf der Krim auf ihrer Seite. Das wird sich nicht leugnen lassen. Trotzdem war es ein Angriff auf die Souveränität der Ukraine.
For the sake of a peaceful transition from a military dictatorship to a democratic regime, for the sake of that transition, they granted amnesty to some of the military leaders, including General Pinochet. That is a decision in favor of peace over justice. And it is a decision that should always be made with reflection, with serious reflection. We see it being made again, perhaps in Colombia, where the people are now voting on a peace treaty that might bring some of the criminals to justice, but will certainly not guarantee that justice will be done. But it does hope to guarantee that peace will prevail. And I think agreements of that sort have to be internationally respected. The people of Chile can revoke the agreement and bring those military leaders to trial. But an international assault upon agreements of that sort might make peaceful transitions much more difficult than they ought to be. Now, I'm not sure that peace over justice is a universal principle, although it may come close to that. But I do think that there will be occasions when the sacrifice of justice for the sake of peace is justified.